Hello, and welcome back to the Beach House 34 podcast. I'm your host, Christine Worth. A special welcome to all of our new subscribers and a big thank you to all of our loyal listeners. Today, we continue the coverage of the Darlie Routier trial, and we are focusing in this episode, and likely the next, on the testimony of the FBI agent named Alan Brantley. Now, in the last episode, let me do a really quick recap for you. First of all, in episode number 1, not the previous episode, but in episode number 1, the defense got surprised by the introduction of some of the information that Brantley was going to testify to on the stand. He had access to some documents and some images that the defense had not reviewed. And this led to this kind of a pretty heated legal back and forth. But despite the objections of the defense, the judge did allow Brantley to testify. And that's what happened in the last episode, which was Alan Brantley Part 2. He has a pretty significant background in analyzing violent crimes, and he went through and talked about his entire professional experience, his educational experience. But the key parts of his testimony was that it started off just flat out. He was asked, hey, what do you think about this crime scene? And he said that he believed that it was staged and that the killer was likely someone that was known to the victims. He talked about several things that he saw at the scene, such as the knives that were supposedly used in the crime, especially the bread knife. I can't say knives, not both of them, but the bread knife that was evidently used to cut the screen was put back into the knife block on the counter. He talked about how if it were an actual stranger that would have walked into the home, that person would likely not known of where they were going. And there would have been a lot more things that were knocked over or moved or broken or what have you, just simply based on the amount of devastation that had occurred within the house. One of the things that he did mention was that he noted that whoever this was seemed to focus on the kids first, which was incredibly unusual. Most offenders would actually go after the greatest threat, the adult in the room. And he concluded from what he had learned from all of this information that it was the children that were the primary targets. If you haven't had an opportunity to listen to part 2 of his testimony, which was the entire prosecution's side of the argument, actually, I highly suggest that you do so. There was a lot of moments in there where it did kind of take you back and think, well, yeah, he has a point. And then other ones where you kind of thought, well, yeah, but. So I do suggest, if you're interested, go back and listen to Alan Brantley Part 2. In this episode, we get into the defense's questioning of Mr. Brantley, and that's where we begin today. The cross-examination begins by Mr. Douglas Mulder. Mr. Brantley, did you prepare a report? No, I didn't. Mr. Hoover doesn't provide you all with typewriters anymore? I don't type, sir? No. Most of my documentation are in the form of personal notes. Now, when I get back to the academy, what I will do is I will memorialize the nature of my testimony, and that will be made the matter of our record. I guess you will send us all a copy? If you would like a copy. Mr. Toby Shuck then says, Judge, I'll object to the sidebar. The court says, sustain the objection. Let's don't get into any sidebars, Mr. Mulder. Mr. Mulder says, Judge, that wasn't a sidebar. That was directed to the witness. The court says, thank you. We understand what you mean. Mr. Mulder then continues. Mr. Brantley, you have prepared some notes, I guess, in the course of your work. Is that right? That's correct. And I believe you, in the Bureau, you have opened a file in this particular case on September the 20th, and you were assigned to the case at that time. Is that right? Well, in actuality, the case was already opened, but I had it assigned to me in our unit on that date. Well, what I do have in the way of a report, which is in the form of your personal notes, which I will mark for identification and record purposes as Defendant's Exhibit number 64, is this a copy of your notes? That is. They are rather difficult to read, but you have been good enough to translate for us where we needed to, haven't you? That's correct. And it says here, 9/20/96, case opened and assigned to me. Is that right? That's correct. Okay. That would be September the 20th of 96. That's correct. All right. And then it goes on to say that on September the 30th of 1996 through October the 3rd of 1996, some 4 days or so, you met with the prosecution, the police, the forensic people, and the medical examiner's people. Is that correct? That's correct. Okay. You didn't go in the house, but you went out and looked at the house? That is also correct. Now, I think risk factor was one of the things that you considered. And you said that you considered the location of the house and whether it was in a development and the access to, I guess, avenues of escape that a perpetrator would consider if they gave a crime like this some thought. I looked at not only avenues of escape, but avenues of approach also. Those are two considerations that I look at. Okay. And as a matter of fact, it's just a block or two off Del Rock Road, which is a major thoroughfare there in Rowlett, is it not? I believe that's fair to say. Yes. Okay. And is it fair to say that it's about 2 minutes going one way from Highway 66 and going the other way to Interstate 30? I believe that's correct. Okay. So anybody interested in getting out of the area could probably, if it took the police 2 or 3 minutes to respond, they could be on I-30 or Highway 66 in the same amount of time, couldn't they? I believe that's correct also. It's fair to say, isn't it? Yes, sir. Now, I noticed in your notes, and I still have difficulty reading your notes, but I noticed there that you had as one of your considerations, and let me stop right there. But is it fair to say that your opinion, for whatever it's worth, is no more valid than the validity of the information that you received? Well, I think certainly it's fair to say that you need to have accurate information, or as accurate as possible, to come up with an accurate assessment. I mean, it's the old garbage in, garbage out type of deal that we have. That is fair to say, certainly. So if you received misinformation, that could certainly affect the validity of your conclusion. It could. And I understand that you have not pointed the finger at anybody in this courtroom, but you have, by what you've said, certainly narrowed things down, haven't you? I believe that is accurate. Yes, sir. Okay. And you said that the children were killed by someone you felt who knew them and knew them well? That is what I said. Yes, sir. Okay. Now, one of the things that you said, and you are primarily, Mr. Brantley, what they call a profiler, for lack of a better word. They refer to us. The title is supervisory special agent, but we have been called profilers. We have been called violent crime specialists, crime scene analysts. We go by a variety of terms and labels. Okay, I'm sure you do. I read a book by one of your colleagues, John Douglas. I had no way of anticipating that you would be with us this month or next month or however long we are going to be here. But John Douglas is one of I think he calls himself the originator, or what is he? I don't know if he calls himself that. He certainly was involved in this program for quite a number of years, but there were people that predated him, certainly. Well, he may have exaggerated his own position. Have you read his book? I have, sir. Okay. I am cited in it, as I recall. All right. All right. I read that thing, and it's interesting because you, as a profiler, you will go and review the information of a particular crime scene or an event, and then, at least Mr. Douglas would, I don't know whether you have this, well, I'm sure you do, whether you have the ability, but Mr. Douglas would, after he looked at a crime scene, he would say the victim or the perpetrator is a white male, 21 to 23, lives within 2 or 3 blocks of where the crime was committed, probably stays with some relatives, is dysfunctional in some respects, and will do this again, and drives a Volkswagen, probably red. Do you remember things like that he would write in this deal, where he would even predict the color of the Volkswagen? I don't believe that is accurate. No, sir. Do you remember where he predicted the color of the Volkswagen that the man was driving? Well, on occasion, what we do, and I can't speak for John or what he has written or account for that, but what we do on occasion, we may talk about the type of vehicle that someone may drive. But as far as I go and my understanding of the limitations of this process, we don't get into predicting or assessing vehicle color. I don't. All right. Well, you don't. But if you will go back and reread, you will find that he predicted even the color of the man's car. And I wondered at that time, and I'll ask you, do you all keep statistics as to when you are wrong? Well, first of all, I think I know your understanding of this process so far has been based on that one book. But I think a lot of that book is accurate. A lot of it is inaccurate. I think what you have to understand, first of all, I think you are describing a profile. And what we did in this case was not provide a profile. No, I understand. That wasn't an answer. I appreciate the information. That wasn't an answer to my question. What you did in this case, you took the answer and you worked backwards. You came in after Mrs. Routier had been arrested and indicted, and her trial was set, and we were fixing to pick a jury. And you worked backwards from the fact, didn't you? Well, I did get involved after she had already been identified. That's correct. Yes, sir. Let me ask you this. If you interviewed people who were friends and associates of Mrs. Routier, did you do that? No, sir. Did you have reports of people who were friends and associates of hers? I did. And who might that be, for example? I would have to go back and look. To be exact, several neighbors, as I recall, and co-workers. I believe there was a report, an interview with a housekeeper or maid. Okay. Did you put particular stock in what the coworker said and what the housekeeper said? No. And what I did, and again, I was wanting to take in all of the information available. There was obviously some information that I discounted or thought was unimportant from the standpoint of what I do. Primarily, what I was looking at was victimology, information about the victims. Yes, sir. Yes, sir. If you would just... We're going to get through this. I think your time is very valuable. Thank you. And I'm going to go through this just as quick as I can. And if you will just answer my question instead of giving a dissertation. Mr. Shook says, well, Judge, I object to that. The court says, sustain the objection. Mr. Mulder says, well, Judge, if you will caution the witness to just answer my question, we are going to get along fine. I am not going to drag this out. The court says, Mr. Mulder, ask your next question, please. Mr. Mulder then continues. Yes, sir. Did you put any particular credence in what as you have termed, her housekeeper or what the coworker said? Again, I reviewed it. I took it into consideration, but I don't believe I weighted that quite as much as I did other case materials. Well, before you weighted it at all, would it be important to you, the mental health and whether or not either one or both of these women had been institutionalized? Certainly. How would that affect your judgment in evaluating the coworkers' information? Well, it would be important. Mr. Shook, again, says, Judge, I'm going to object here for going into facts not in evidence and for going way out. The court says, I'll sustain the objection. Mr. Mulder says, well, Judge, I'd like to be heard on this then, outside the presence of the jury. Let me have my exhibit and let him. Mr. Shook says, Judge, could we approach the bench for a moment? The court said, yes, you may. What do you have? Let's see what we have. Mr. Shook says, could we bring this exhibit with us, please? The court says, would the jury please step outside to the jury room briefly, please? All right. And then outside of the jury, the court says, let the record reflect that these proceedings are being held outside the presence of the jury and all parties in the trial are present. All right, Mr. Mulder, you may proceed. Mr. Mulder says, Judge, my position is simple. This man said he had received information. And if this is the woman, and we have not established that yet, but if this is the coworker and he took her information into account and he said her mental health would be important, then he has a right to know that she is a nut. It is that simple. Mr. Shook says, Judge, Mr. Mulder says, she has been diagnosed as having a borderline personality disorder. And he will know this, that one of their characteristics is that they are untruthful. The court says, let the record reflect that the court is holding Defendant's Exhibit 45, which was admitted for record purposes only. It was not admitted earlier in the trial. And so what you want to do is get it admitted now for all purposes? Is that correct? Mr. Mulder says, no, I just want the witness to look at it. And I don't want him to take my word for the fact that she has been diagnosed as having a borderline personality disorder. I'll let him look at it himself. The court says, all right, I'll sustain your objection. Mr. Shook then says, Judge, I'll object to him going into any line of questioning about her mental history. You have already ruled directly when the witness was on the stand that that particular exhibit and questions going into that exhibit were not admissible. So you can't bring it in through the back door, through the agent, who just testified that he looked at some witness statements of a coworker and he already, the court says, I'll sustain the objection. Mr. Mosty says, Your Honor, here is a stack 6 inches thick of things that he has considered, including newspaper clippings that are not in evidence. And he gets to let the state give him evidence, things that are not in evidence, and draw his conclusions. And we're precluded from giving him information that might change his opinion. The court says, we're speaking specifically about Exhibit 45. That is my ruling. Please, let's proceed. Mr. Mulder says, Judge, excuse me. If I just might be heard on this so that my position is clear, may I have permission from the court to speak? Well, yes. Mr. Mulder says, thank you. The court says, by all means. And then Mr. Mulder says, Judge, he has stated that he considered her opinion. He said he would also consider her mental health or lack thereof. You know, they have got to take the bad with the good. If they want to put him up and they want him to consider people like Miss Jovell, then they have to take the bad along with that. Her baggage comes with her, you know. The court says, thank you. The court's ruling remains the same. Objection is sustained. Next question. Mr. Shook says, Judge, if that's all we have along these lines, then we will ask. The court says, I guess we will until we see what the next question is. Mr. Mulder says, well, Judge, I would prefer to question him in front of the jury, if that is all right with the court. The court says, are you through with this hearing now? Mr. Mulder says, yes. You have cut me off. You won't let me. Mr. Shook says, well then, Judge, we will object further to any interrogation along those lines. And you know, if that is what we're going to have, we need to get that hashed out now. The court says, well, I don't think Mr. Mulder will go into those other things. Mr. Mulder says, why don't you just cut me off from all cross-examination? The court says, well, no, I can't do that, Mr. Mulder. We'll bring the jury in. You may continue. Mr. Mosty, also of the defense team, says, we can't provide him any information that he might use in formulating his opinion. The court says, we will go question by question, and Mr. Mulder is handling this, and he will do all the talking for the defense. Mr. Mosty says, can I make objections outside of the jury's presence and comments for the court? The court says, right now you may. Yes. Mr. Mosty says, thank you. Mr. Mulder then says, so he can confer with me too, can't he? The court says, oh, yes, he can, as long as it is done in soft tones. Mr. Mulder says, we'll confer in sign language, Judge. The court says, well, no, that will not be necessary. Bring the jury back, please. So after all of that, the jury comes back in and the court says, let the record reflect that all parties in the trial are present and the jury is seated. You may continue, Mr. Mulder. And then his cross-examination is resumed. Yes, Mr. Brantley, I believe I had asked you, If you all kept, you, the FBI, and the behavioral science unit, if you kept statistics as to how often you're wrong. Well, we don't look at it in terms of how often we're wrong. I think we like to consider how often we're accurate or correct, but we do keep statistics. We do keep some figures. We are attempting to collect more and more of those, say over the past year or so, but we do try to do that. That is correct. Is that, will you translate for me? Was that a yes or a no? Well, do you keep statistics as to how often you are wrong? I don't, but there are people at our unit that do. I guess that is probably the best way to answer that. Okay. And certainly you don't have those with you, do you? I do not. Okay. And you don't know what your batting average is, or do you? The best way I have of assessing that is the overwhelming amount of requests that we receive for our services on a daily basis. I think the consumers determine that what we do is beneficial. Well, sure. I mean, it's impressive to have an FBI agent come in here and work backwards from the answer, isn't it? Mr. Shook says, Judge, I'll object. That is improper questioning and it's argumentative. The court says, I'll sustain the objection. Mr. Mulder continues. Let me ask you this. You said one of the risk factors that you consider when I looked in your notes. You said there was a car in the Routier garage. Is that correct? I don't believe I said that. You didn't? I said, I believe it was in front of the house. Okay, I'm sure you're right, Professor. Mr. Shook says, Judge, again, I'm going to object to the improper questioning and the sidebar comments. The court says, I'll sustain your objection. Mr. Mulder says, he is a professor. He testified that he teaches at... The court says, Mr. Mulder, please cease the sidebar. Ask your next question, please. Mr. Mulder says, what does this say? I'm showing you what's been marked for identification and record purposes as Defendant's Exhibit number 64. What does that say? You are showing me a copy of my notes and work papers. Yes, sir. And I have got this down. Again, a lot of this I was not prepared to testify to because I later learned that it was inaccurate. The question I had before I arrived here or wanted to confirm was where the location of the vehicle was. I wanted to know whether it was in the garage or where it was located. I was informed it was located in front of the residence. Okay. When you were so good as to read that, can I have it back, please? Sure. You have got a copy of it right up there, don't you? That is my original. Yes, sir. When you were so good as to translate this for me because I couldn't read your writing, you didn't tell me that that was one of your questions, did you? I don't believe you asked me that. I mean, you were just having me read that for you. Well, you said evidence that occupants are home, the TV on. Well, let's see what you wrote down. And when did you make these notes? Now, that copy, what I did is I had a lot of other notes that I consolidated. No. My question was, when did you make these notes? Probably within the last 2 weeks. Okay. So you knew within the last 2 weeks your question about the car in the garage had been answered, hadn't it? I don't know if I understand your question. Do you think there was a car in the garage right now as you sit here today? My understanding is that there was not a car in the garage. Well, why did you put evidence that occupants are home, TV on, light in Roman room, and shades or blinds up and vehicle in garage? Why did you put that in your consideration? Those were things that I wanted to understand or make sure that I had as accurate information. Matter of fact, the car wasn't in the garage, and you now know that, don't you? That is my understanding. Okay. Matter of fact, the vehicle that Mrs. Routier drove was parked out in front, wasn't it? That is my understanding, was there was a vehicle in front of the house. And the car her husband drove, the Jaguar, the 1987 Jaguar, traditionally was parked not in the garage, but in the driveway, wasn't it? My understanding was that is also accurate. Right. Of course, it had been in that garage for the last 2 days. That was your understanding too? So, for all outward appearances, anyone who knew that house or knew that area would think that the wife was home and the husband was gone. Is that reasonable? All I was looking at, again, not necessarily who specifically was home, but just that there was some indication that someone was home. Well, you quarrel, of course. The object of the intruder's crime in this case could well have been the mother or the woman of the house, couldn't it? It could have been. All right. And anyone, like I said, anyone familiar with that house and with the occupants would know or would assume that the husband was gone because his car was gone. That's possible. But she was there because her car was there. That is possible as well. Okay. You stated, and I wrote it down, that the focus of the assailant was on the children. Is that right? That's correct. I wrote that down right? I'm not sure what you wrote down, but that is what I testified to. Okay. And how do you know that? How do I know that they were the focus of the offender's interest or assault? Yes, sir. I think it's fairly obvious from the nature and severity of the trauma they sustained and the location of the trauma. Again, the placement of those wounds for maximum killing efficiency, that pretty much stands out to me. And I think you told us that the children were attacked first. It appears to have been the case. That's correct. Okay. It appears to you, but it's not quite as apparent to me. Could you enlighten me as to how you reached that conclusion? Well, in part from the witness's description of events. Are you talking about Mrs. Routier's? That's correct. Oh, she told you the children were attacked first? I was able to review her statement. And it says in there that children were attacked first? She indicates that, as I recall, that when she awakened, that the intruder, a white male, was standing at the foot of her couch, and she also had been touched by one of her sons who had already been wounded, and immediately the intruder started to exit. Okay. So I think it's reasonable to assume that the children had already been attacked because that would have left no room for that to have occurred. If he made his exit, then she had already been attacked too, hadn't she? That is reasonable. But I mean, how do you know the children were attacked first? Well, again, you wouldn't know for sure, and it's tough to accurately or at least specifically reconstruct events, but that is my opinion. All right. Your opinion is that the children were attacked first. That's correct. And I'm not going to change your mind, am I? Well, if you have additional information that I should consider, I would be willing to entertain that. Consider that. You are not the type of guy who says, I have made up my mind, don't confuse me with the facts. Are you? I hope not. But you're telling this jury that, based on your expertise, the children were attacked first? That's what it appears. Okay. Would you tell the jury the extent of Mrs. Routier's injuries as you understood them, Mr. Brantley, or Agent Brantley? Right. My understanding is she has a wound to the left shoulder, has a wound, actually 2 wounds to the right forearm, and she also has a wound to the neck. Okay. And those were superficial? I remember from reading the medical reports that they had been described by the medical professionals as superficial. And what does that mean to you, Mr. Brantley? I think they were also qualified further as not life-threatening. Is that what that means to you? Superficial means not life-threatening? That certainly was taken into consideration, but I think also the depth of the wounds and the amount of structural damage that has been committed. Is the carotid artery in your vocabulary a vital organ? I would say the carotid is a very important vessel in the body. That's correct. Okay. And you think if the carotid artery were missed by 2 millimeters, that is a superficial or not life-threatening or an unimportant injury? I certainly looked at that with great interest. And again, relied on the accuracy and reliability of the medical professionals that did the assessment and wrote the papers. Is that where Dr. Parchman Townsend comes in? No, I don't believe so. She was the medical examiner that did the autopsy on Devin, I believe. Did she tell you when she looked at Mrs. Routier's injuries that they were bandaged? I don't recall that we talked as much about the bandaging as we did other issues. Mr. Brantley, can you tell me how many weapons you assumed were involved? To my knowledge, based on the facts and circumstances, it looked like 2 knives in the home were involved. At least those were the only ones that demonstrated through forensics and through examinations that they had come in contact with either blood, fibers, or rubber particles or glass fragments from a window screen. As a special agent, you are no doubt aware of the laboratory that the FBI has in Washington, D.C., are you not? I am. Okay. Do you know whether or not the bread knife was ever submitted to the laboratory in Washington, D.C. that is run by the FBI? I don't believe that it was. Okay. And if you talked with Mr. Lynch, you know that he was only able to make, because of the minute quantities of the fiberglass and the rubber dust, he was only able to make a visual examination in comparison with the screen. Did you know that? I'm not sure I understand your question. The visual, he was only able to eyeball it and say, it looks the same. Well, my understanding, it was a microscopic examination, if that is what you mean. Well, he had to look through his eyes into a microscope. Certainly, but not physical with the naked eye. It was microscopic. It was so minute that you couldn't see it with the naked eye. It was microscopic. Yes, sir. Okay. And did you take that into consideration? And did Mr. Lynch tell you, and I don't know where the knife is, but I'll use this because it really doesn't make any difference. But did Mr. Lynch tell you that he didn't know where on the knife he found the fiberglass rod and where on the knife he found the rubber dust? I don't recall if we got that detailed. It was just indicated to me that there was the presence of those items on the knife. He may have, however, he may have told me exactly what the location was. Did you examine that screen? Did I examine the screen itself? Mm-hmm. No, sir. To know that you could it's of such a fabric that you could cut it with relative ease, that doesn't surprise you, does it? Well, I really couldn't testify to that. I have not examined the screen. I have been told by others that the composition of the screen, well, would it, as an FBI agent, would it make a difference to you that if the window wasn't raised all the way up, that the knife, when it cut the screen, of course, couldn't go in more than about, 2 inches? The screen fed over the window, say an inch or 2. And if he found what he found up in here, it has absolutely nothing to do with the case. Are you following me? I think so. If you go with your theory that the window is closed, again, well, do you know whether it was open or closed? I do not. But that doesn't make any difference to you, does it? Well, it could, as you say. If the particles that are found further up on the knife, then that would suggest that the window was open, possibly, and you didn't have that obstruction for the knife. Because that fits your conclusion? No, I haven't testified to anything about the condition of the window. Well, I mean, that knife may not be involved in this case. The knife you just showed me? Well, the knife I showed you was not the bread knife. That's correct. Did you know that that there has been testimony that this knife does not have the blood of Devin Routier on it? You're asking me if I'm knowledgeable about the testimony that has gone on about the knife? No, I assume you have not been told what the testimony is. I have not. But I assumed the prosecutors shared that with you. About the testimony that has occurred about the knife? No. I assume they knew ahead of time. But this knife, there has been no testimony that there has been testimony that no blood of Devin Routier is on this knife. Now, did you form an opinion or did you make an assumption as to how many knives were involved in the assault, in the cutting of the 3 victims? Well, I didn't assume that, no. What I looked at and what I found to be reasonable was that the butcher-style knife or chef's knife, whatever you want to call it, that was found saturated with blood was indeed used in some assault there at the residence. Again, it was not until later on, when it was processed, and they came up with the information about the blood types, that we went beyond that. Okay, so you do know what the blood types are on the knife? My understanding earlier was that it looked like they had blood types of both boys on the knife. Okay, well, if you have received information, well, you may not have received the same information that this jury has received. Or this jury may have received information that contradicts reports that you have received. Can you appreciate that? Well, I have no way of knowing that, sir. No, but you can. Can you appreciate that? That maybe the reports that you have seen don't jive with what the witnesses have testified to before the jury? That could be possible. Okay. Now, you can't tell, I dare say, which of the youngsters was stabbed first. I wouldn't make that assessment. No, sir. But you are telling this jury that you assumed that the one boy had been stabbed some 4 times. Is that right? In the back? As I recall, I believe it was Damon, the youngest, had 4 stab wounds and 2 fairly large incised wounds to the back for a total of about 6 wounds to the back. All right. And the other youngster received 2 primary wounds to the chest, 2 deep penetrating stab wounds, and some other. And did you assume that all of those wounds were inflicted with the same weapon? I didn't assume that they had been, but I believe from my recollection of information of events that the wounds appeared to be consistent with having been made by that butcher knife. Okay. Was that a yes or no? Well, you'll have to ask me that question again. I'm not sure. I asked you if you assumed that the boys were cut and stabbed with the same weapon. Again, you say assumed. I looked at all the possibilities and considered all the information before I make my determination or assessment. Now again, early on, I'm not going to assume anything. If you have additional information that I can consider, I will consider that. Okay? Again, my opinion is not locked up or carved in granite. Well, I would think before you get up here and give a jury some opinion about who might have killed or attacked some children, that you would have some idea as to what went on. Well, maybe it's a semantic thing that you are talking about assume. I think I'm relating that to kind of quick to react and quick to or jump to conclusions, and that is not what I'm doing. Are you assuming now, as we sit here today, that one weapon was used to assault those children? It's my opinion that, again, that butcher knife was used to kill those children, to the exclusion of all others, to the exclusion of the others that were discovered at that scene, covered in blood and reported to be handled by the offender on his exit. Okay, I just want to make sure I understand. And you're saying that that was the only weapon? You have ruled out any other weapon? Again, not to my knowledge. There was no other weapon discovered at that scene that had on it the victim's blood and that was reportedly carried and dropped or thrown down by the offender as he exited. All right. Okay. Did you assume that both Devin and Damon Routier's blood was on this weapon? The information that I had available to me was that that is indeed the case. That is the case? Yes, sir. All right. Thank you. Now, may we assume further that you don't know which of the boys was stabbed first? But did it make sense to you, based on your vast experience, that the 6 injuries to the one youngster, to Damon, were received at approximately the same time? I would say they were coincidental to that event if you consider the event the assault of the 3 members of that family. So, in other words, the perpetrator, whoever that might be, stabbed Damon and cut him 6 times, and then stabbed and cut Devin some 2 times, and then the knife was turned on Darlie. Is that right? That is, if that is the order, you believe it. I haven't said that that is the order. No, I can't state that. Well, It could have been Devon first. It could have been Damon first. Either one, it could have. All right. But the boys were before she was assaulted. That is my opinion. Okay. And then after the boys, after the assault was finished on the boys, then she either herself inflicted those wounds or somebody inflicted the wounds upon her. Is that, are we on the same sheet of music? I think that is reasonable. Okay. It doesn't make sense to stab one of the boys and then stab the other boy and then cut her and go back and stab the other boys again, does it? I'm not sure I understand what you mean by make sense. Well, I mean, that is what your whole premise is built on is common sense, isn't it? Again, I'm not sure I understand what you are saying. My opinion is based on a number of years of training and experience and education. No, I know all about that and working hundreds of these kinds of cases. Yeah, we know all about your education and your training, but the whole thing is based on common sense, isn't it? I'll tell you if you will allow me to explain this, I believe in the rule of thumb, but be aware of the obvious. I try not to overinterpret or overanalyze. And I think, again, what I have testified to are major features. Things that I believe most people, once these things are explained to them, and again, things that may be beyond what they encounter in their daily lives, I think it really does make sense to people once they have all of the facts and circumstances. The whole thing is based on common sense, isn't it? I know you have got experience. Have you actually worked murder cases? I have, yes, sir. Okay. You weren't a street officer with any PD or anything like that, were you? No, I was not. Okay. And when I say worked a murder case, would you work murder cases in the District of Columbia? I have not. No, sir, not in the District of Columbia. Okay. I take it is someplace other than the District of Columbia? That's correct. What did you do with respect to the particular murder case? When I was assigned to our office in Connecticut, we did a nationwide roundup of the Hells Angels motorcycle gang, and there was a homicide that occurred while we were investigating that group. We had to respond to that scene and do some inventories and some data collection. Okay. Is that the extent of the murder cases that you yourself have worked? On the scene, however, I have worked hundreds of murder cases at the National Center. Yeah, well, a lot of that stuff is telephone too, isn't it? I'm sorry? Where you talk to somebody on the phone and give them advice? Well, we do quite a bit of what we do on the telephone. That's correct. But we also make on site visits and we have investigators that come back to the academy for consultation. Now, in the course of your reviewing the facts, you told us that you read the various reports of the police officers. Is that right? That's correct. Okay. And I think, one thing that kind of stuck out in my mind, you said you made the inquiry as to whether there had been any similar crimes in the neighborhood. That's correct. Similar or related offenses. Why is that important? Well, if you are trying to consider whether this may be a part of a series, that certainly would be important to know. Okay. And I think I heard you say something, but you didn't expound on it. But there was something about a car, a black car that was in front. Do you recall reviewing one of the officer's notes where he questioned the lady directly across the street who said that she was awakened that morning by a scream and thought it was a slumber party the people were having next door? And she looked out and she saw a small black car out there with dark windows, and she assumed that it was a slumber party and nothing going on, so she went back to bed. And then she heard the emergency vehicles out there, and then she got up and looked out again, and that vehicle was gone. That small black car with the tinted windows that didn't belong to anybody in the neighborhood. What did you make of that, Agent Brantley? I don't recall reading that. Oh, you don't? No. Well, let's see if we can find that for you. Would that make a difference? I would certainly take that into consideration. Well, before I go to the trouble of finding it, I want to know if it's going to make a difference. A major difference? If not, we'll go on to something else. You mean, will I change my opinion? You are not going to change your opinion, are you? Not based on that information. No, sir. All right. I'll just move on to something else then. But you didn't inquire about it or say, hey, what is this black car doing at 2:30 in the morning where it has no business being and nobody knows anything about it? Why is it out there and why does it leave right after the scream for help? I, not that specific incident or that specific vehicle. I did ask many, many questions about people that lived in that neighborhood. Anybody that might have had a history of problems or arrests and convictions. I mean, any of that information, certainly I would want to know ahead of time. Okay. Now, you said you took into consideration this business about no evidence in the den or the Roman room or the family room, call it what you will, of a violent struggle. Is that right? I don't believe I characterized it quite that way. Well, you were the one that I wrote down violent struggle. I mean, I got that from you. There was certainly evidence of a violent struggle. Again, when you look at the quality and the nature of that struggle, it would certainly seem to be less than dramatic. Mhm. Certainly, in the hundreds of cases we have analyzed in the past, when you see a violent struggle between two adults and there is a knife involved as the weapon and people have been cut, you generally see a considerable amount more of disruption than we saw in that. Hey, I agree with you wholeheartedly. But who told you to look for a violent struggle? You said you read her statement. She didn't say anything about a violent struggle. You just said that she woke up and saw this man walking away from her. She didn't say that she engaged in a violent struggle with him. Why are you looking for a violent struggle? Well, I had all of the crime scene photographs, and certainly they depicted a certain amount of violence. So it wasn't that I relied on that, but that was obvious, a violent crime scene. And I recall from not only the statement that she had made, but from other interviews and witness statements that she had also talked about that. So I had gotten that information from them. Okay. I mean, because you saw a lot of blood there on the carpet, I don't understand your question. I mean, that is why you thought there was blood on the carpet? Because there is a lot of blood on the carpet, did I assume or believe that there had been a violent confrontation there in that location? Is that what you are asking me? Yes. Yes, that's reasonable. Okay. You don't know, and again, you don't know what the first responders, how they may have changed the scene, do you? Well, it's certainly a question that I asked. Okay. And I wanted to get some information about that because that is important also to consider. You considered the vacuum cleaner, didn't you? I did. Okay. And I noticed you've made a comment about the cord, haven't you? I did. And you said something about the way the vacuum cleaner cord was coiled up. Didn't you say something about the way the vacuum cleaner cord was coiled up that gave you some concern? I don't know if I said the word coiled, but certainly the way it was underneath the base of the vacuum was of interest. That's correct. It appeared to be more stacked or than coiled, I think. And you said it looked like it had been placed there as part of staging. That's correct. I believe that was indicative of the staging that occurred at the scene. Okay. Let me hand you what's been marked for identification and record purposes as Defendant's Exhibit number 65. And I'll ask you if that is the photograph that you are talking about. No, it's not. Okay. Let me show you what has been marked for identification and record purposes as Defendant's Exhibit number 61. I'll ask you if that is the photograph. No, it's not. Okay. There was another one. There are several others. Well, I'll be happy to. The cord appears to be in a different position. I don't know whether it's the same or different. Is there another photograph that shows it better? There were several of them. Yes, sir. Okay. The court says, did you offer that for record purposes only? And Mr. Mulder says, no, no, I offered for all purposes. But the court says, any objections? Mr. Shook says, no objection. Can you show me the picture that you are talking about? Sure, there are four. Okay. Let me show you what has been marked for identification and record purposes as 66, 67, 68, and 69. And I'll ask you if those are the photographs that you were telling us about. Yes, they are. Okay. And what is it that your keen eye caught about the cord? I think it's probably best depicted in what you described as defendant's exhibit number 67. Okay. Where the cord, and the court says, you may show it to the jury. Mr. Toby Shook says, Judge, so it's clear. Are those in evidence? Mr. Mulder says, yeah, I'll offer them into evidence. The court says, are you offering them? All right. Any objection? Mr. Shook says, no objection. And then the defendant's exhibits numbers 66, 67, 68, and 69 are admitted. And the witness continues. Where the cord seems to be underneath the base of the vacuum cleaner and kind of in a focused, the court then says, you may have to speak a little louder so the end jurors can hear you. The witness says, I'm sorry. Where the cord is underneath the base of the vacuum cleaner, and it seems to be focused and kind of stacked on top of one another. It certainly does not present with the appearance that this has been snatched and thrown or otherwise violently placed in that position. The court then says, if you could step down and just go down the aisle and show it to all the members of the jury. And at this point, the witness steps down and approaches the jury rail and for the purpose of further describing this exhibit. Mr. Mulder then continues. That appears to you that was done with a great deal of concern and design. Well, you see here, this cord seems to be very focused at the bottom of this vacuum cleaner, not stretched out or elongated, as if someone grabbed it or snatched it. You would have anticipated the cord would be elongated, especially if it had been plugged in, obviously. But again, this appears to have been held, placed underneath the vacuum cleaner base placed on top of it. And then, considering the amount of blood on the handle of the vacuum cleaner, looks like that is the area that was grabbed. So not thrown off at the top of this. Also, again, because of the bloody footprints underneath the vacuum cleaner that were discovered, it was clear that someone had obviously walked through that area just prior to that vacuum cleaner being placed there. And based on your experience, what do you make of that? That someone was interrupted while vacuuming? Well, in my opinion, this vacuum cleaner was placed in this position as part of the staging of the scene. For what? To make it look, I believe, that the offender wanted to make it look like a violent struggle had occurred, and this had been knocked over during the course of that struggle. But again, because of some things that I have already outlined, this is a major contradiction of that kind of theory. Okay, so you think that the court then says, if you want to have a seat again, please, sir. And at that point, the witness then goes back onto the witness stand and Mr. Mulder continues. You think that the perpetrator wanted somebody to think that there was a fight going on around not over the vacuum cleaner, but around the vacuum cleaner. This is close to the kitchen sink, isn't it? It is close to the kitchen sink. You said you read her statements. She didn't say anything about a vacuum cleaner, does she? I tell you, that was another thing that was considered. What was conspicuously absent was the comment by anyone about the vacuum cleaner. And again, other things were commented on, but there was absolutely no mention made of this vacuum cleaner. It was totally avoided, and I thought that was interesting. Well, now, if I don't know as much as you do, obviously, but if I had wanted to find out how that vacuum cleaner got there, Agent Brantley, I would have asked the first officer on the scene if he saw a vacuum cleaner out of place in the kitchen. And if he said no, then I might think that maybe one of the first responders got it out of the way in their emergency. But did you talk to Waddell? I did not personally talk to him, but didn't think it was necessary. I talked to the prosecutors and the other investigators involved and certainly asked that question. I wanted to know if this was discovered in this position and if this photograph accurately depicted that position of the vacuum cleaner. I was advised that that indeed had not been handled by the paramedics or any of the responding officers. Okay. And of course, you took that at face value, didn't you? Well, I considered that to be accurate information at that time. Yes, sir. Okay. Now, you are familiar with staged evidence or throwdown evidence, aren't you? I am familiar with staging. You have heard the term throwdown evidence, or I guess if you have not been a street cop and haven't worked a lot of these things, you probably haven't heard the term throwdown evidence. Well, I have heard the term, yes. All right. If someone, let's just use planted evidence, does that have a better connotation? I mean, is it clearer? I have heard that term used as well. Okay. Assuming that someone wants to plant evidence to either divert attention from themselves or avert attention to someone else, what is the first thing and the most important thing that they want to achieve? What is the most important thing to them if somebody is going to plant evidence? You mean besides diverting attention away from themselves? Well, isn't the, if you are going to plant evidence, you don't want to plant evidence that is so subtle. The police might, in their zeal, overlook it, do you? If you are going to plant evidence. So, the most important thing to somebody who plants evidence is that the police find the evidence, and they can't very well find it themselves, can they? I'm not sure I understand your question. It doesn't do any good to plant evidence if the police don't find it, does it? That is a fair statement. Okay. So, therefore, it must be very important to somebody who plants evidence to see that the police find it. All right. I can go along with that. You can go along with that? Yes. Okay. And generally, don't you find that planted evidence is overdone? I think that is also fair to say, especially with people that don't have a history of committing violent acts. They stage it, they try to make it look like they think it should look, but don't necessarily base that on experience or knowledge of doing it before. Okay. And rather than a sock with a smidgen of blood on it, you find a blood soaked sock at the end of the driveway or something that is obvious. It's got to be, of course, for the police to find it. Many times it's you want something that they are going to find and not something that they are going to overlook. So you want to make it fairly obvious, don't you? Well, I have seen that before where people do make things very obvious. Okay. Now, if you are asking me whether I think the sock was placed in an obvious location or not, I could answer that. Well, I know you want to answer it, and I will just wait and let them ask you if you will. All right. I think you have answered it or given us your view on it. Well, because you said he had gone back down, you know the perpetrator had gone back down into the development. Someone had. Hmm. Whether that was the perpetrator or someone else, I wouldn't be able to make that determination based on the location of the sock. So you are saying that the perpetrator might have been aided by someone else. Is that what you are saying? Or there may have been two perpetrators? I'm saying that anything is possible. I'm not saying that that is the case either. Okay. Well, let me just ask you this. As an expert, how many perpetrators did you see involved in this event? From my review of the case and all the materials, to me, it appears that there was only one individual involved in the assault. Okay. In the assault, in the crime, in the planting evidence? Exactly. And again, that was based on my review of the scene and also from the statements from the surviving witness. Can you just give us you say there was one person involved. So the one person killed both of the boys and then cut and slashed Darlie and then planted this sock, this ruse, this as part of the staging. It was my opinion that the sock was located out and as part of the staging event. Could you please just give the jury a chronology of how this took place, would you please? Well, I cannot give you an exact chronology, but what I believe occurred is that the offender in this particular case, I think at some point, at some level, realized, hey, this crime scene, for the most part, really does not go beyond the confines of this residence. And maybe I need to leave some sort of trail to suggest that the intruder, if you will, has come from the outside and again also has exited. I don't want to interrupt you, really, but I want you to tell them at what point this perpetrator realized that. As soon as the two boys were stabbed, or after her throat was cut, or after her arms were. Well, this is after the assault on. Is this after her throat is cut too? Well, I couldn't say that. Why not? I just don't have enough information to make that call. But I think what I can say is that that sock was planted after the boys had been stabbed, because my understanding is that, well, that is brilliant because the boy's blood is on it. I mean, there isn't anybody in this courtroom who couldn't have handled that. Great. That was my opinion also. Well, I mean, it's common sense then, isn't it? Well, again, I try to be aware of the obvious. Hey, we know that after the boy's blood was shed, the sock was, it had to be after their blood was shed. We know that. That is a fair statement. All right. Now tell us, please, sir, what happened next? Was the sock, when was the sock taken out there? Well, I couldn't say with any degree of certainty exactly when that sock was placed there. When was the window cut? I couldn't say exactly when that window was cut. Can you tell us who put the fingerprints right up here? Did they tell you that they had an experiment for the jury here? They had a police officer bigger than you are squat down and go. And he too, they said something about the windowsill not being disturbed, the dust on it. You put that in and factored that in, didn't you? That combined with the lack of transferring anything outside the house, mulch, grass, moisture, blood going out the other way, or mud? Mud, exactly. Well, it was not muddy. Why would you expect to see mud? Well, I think with the moisture and the climate at the time is reasonable that some moisture had been picked up and that if that came in contact with dust or dirt, that may create mud. Well, it rained the next day. It rained the 7th. There was a thunderstorm the 7th, but the 6th was hot and dry. Why would you expect to see mud? Again, moisture from the dew in the evening and from, that is the moisture I had in mind. Show me where he is going to step in mud, will you? Show me where the mud is here. That you think he brought some mud with him? Mud is your term. I'm not saying mud. No, you said there wasn't or you didn't see any muddy footprints or you didn't see any mulch disturbed. That's correct. Well, show me where the mud is going to come from. Well, I'm considering dirt. It doesn't have to be mud or a puddle of mud, but there could be some. Well, where is the dirt going to come from, Special Agent? Dirt on the outside of a home here in Texas? This is all paved, isn't it? Well, but still. See the yard there? The grassy area? In some areas, there is no grass. That is bare, exposed dirt. You think this is bare, exposed dirt? That is mulch. It's my understanding that is mulch. Why would you walk through the mulch when you could walk on the sidewalk? You could walk on the sidewalk. I mean, why? Tell me. I mean, I'm interested in this. Why would you walk across the garden part when you can walk on the sidewalk? Well, from interviews of offenders that I have talked to based on my knowledge of that backyard area with the outside lighting and sensor, that one possible reason or explanation is you want to avoid setting off that light or that sensor. So you might want to take as direct, close route to the side of the house as possible. And that is a good point. Yeah, because you actually become more visible or exposed, I think, if you go down the walkway. Yes, sir. And we have a man who performed some tests, but the state hasn't seen fit to bring him yet. But one of the witnesses, one of the police officers testified. Mr. Toby Shook says, Judge, we'll object to the sidebar once again. The court says, sustain the objection. I instruct the jury to disregard the comments made by the attorney. Mr. Mulder then continues. Well, one of the police officers testified that a Sergeant Neighbors did some tests out there, and he said that you could walk from this window through here to the gate and not set off that light. I believe that is accurate. I saw that same report. So the light doesn't have anything to do with it, does it? Unless you are just running around the yard? Well, it is something that I considered. But if you knew that about the light, you knew the positioning of the light and that cone of sensitivity, then you could reasonably assume that. But if you are a stranger and you are not aware of how that light is positioned, you are not going to know that. That wouldn't come on. So you might want to be a little more cautious and you might want to hug the wall of that home a little more closely than otherwise. Well, who said it was a stranger? I'm just saying that is a possibility. Okay. And if you believe that it's a stranger, that's certainly something you want. Or if you don't, not many places have these sensor lights, do they? I'm sorry. Not many, probably 99% of the places don't have a sensor light that goes on like that. Isn't that fair to say? I have no information about that neighborhood. How many people have that light? Any neighborhood? It's fairly common in the area that I live in. Well, it would have to be. You live up there by Washington, D.C. I do. Everybody carries a gun up there, don't they? Or they need to, probably. But at any rate, why would you expect the mulch to be disturbed? If somebody had gone through there, it would be reasonable to assume that the mulch had been disturbed. All right. Now, did you say there was nothing in the entrance or exit that was disturbed? Did you say that? You are talking about other than the screen being cut? Yes, sir. There was certainly a minimum of disturbance, if anything at all. Well, when you say a minimum, what are you talking about? Well, again, going back to the dust and dirt on the sill, talking about a transfer, talking about any blood evidence being brought back there on the exit of the offender. Did you know that when the police officer went through that, the only place that he touched was the place that they found the unidentified prints? I was aware of that. Do you think he just touched it in front of the jury just by design? Or do you think it was just a natural place that somebody would touch as they were going through that window? Mr. Shook says, Judge, I'm going to object to speculation. The court says sustained. Mr. Mulder says, well, he speculated, Judge, for 2 hours. The court says, if you know the answer, answer it. If you don't, let's move on to the next question. The witness says, I'm not sure I understand that question. Mr. Mulder says, all right, we will just move on. And at this point, this is getting a little lengthy, and they move on to a different topic, which touches on the garage. So we will stop this for now and then pick this back up when we get to Alan Brantley, number 4. All right, so let's recap what we've learned in this episode. So from the start, Mr. Mulder of the defense team makes it very apparent that even though this guy works for the FBI, Mulder is not going to treat him any differently than anyone else. As a matter of fact, he actually seems to get a little bit more assertive with him than he has other witnesses. Mulder then starts off by talking about how Mr. Brantley had mentioned that people usually look for easy ways in and out of a location if they're going to commit a crime, meaning the roads that are easily accessible. And Mr. Brantley had said during his questioning by the prosecution that the Routier neighborhood didn't really fit that scenario. But Mr. Mulder then talks about how there is one main road, one interstate, and one highway that someone could get to in less than 2 to 3 minutes, less time than it took for police to even show up at the house. There does come a time when Mulder asks Mr. Brantley to please answer the questions that he's given instead of giving a dissertation which of course causes Mr. Shook of the prosecution to object. But that's all he does. He just objects to it. He doesn't give any reason. The judge, however, sustains the objection and Mulder then continues. Now, Mulder then finds out that Brantley didn't actually speak to any of the witnesses in this case, but rather just read over the information that was given to him. When it came to a coworker of Darlie's who had previously been institutionalized for what we now call bipolar disorder, it gets objected to by the prosecution. However, if you remember back in the testimony of Barbara Jovel, when this information was discovered, the judge did not allow it to be heard by the jurors. So this was, in my opinion, kind of a way for Mulder to sneak this information in there because, the jury at this point is still present. And maybe sneak isn't really the right word. The likelihood is that Mulder felt that this information was important for the jurors to hear. And yes, if I were on the jury, it would have made a difference to me. And the fact that Brantley is using this information as a basis, one of the bases for his conclusion, without knowing the facts regarding her mental condition, it does matter. So after this, Mr. Shook requests a conference with himself, the judge, and Mr. Mulder, and the jury is asked to step out. There is this back and forth between the defense, the prosecution, and the judge about whether or not this exhibit, this 45, which I'm assuming contains information about the mental health of Barbara Jovel, can be used to question the witness, since the witness is actually taking her information into consideration. But he even said that he likely wouldn't put a lot of weight into it if he knew of her mental state. The judge, though, still won't allow it to be discussed in front of the jury. When another member of the defense team then speaks up, he's told that, hey, it's not you, but Mulder who is doing the questioning. And the person who spoke up was Mr. Mosty. And so he responds and says, hey, are you sure? Is it okay that, they can even talk to each other? And the judge says, as long as they're quiet about it. And at this time, Mulder says, well, in that case, we'll just talk to each other using sign language. It's very obvious that the defense team is getting irritated with the amount of leeway that the prosecution is being given. And that even though they have a good argument about Barbara Jovel's mental health, the judge still won't allow it. Mulder then makes a point to say that typically, and this is now that the jury is back in the room, typically it was Darlie's car that was in the garage and Darren's car in the driveway. But this particular night, Darlie's car was out front and Darren's was not there, which would lead you to believe, or lead someone to believe, that if you knew the house and how it operated, that the husband, Darren, was not home and that Darlie was the only one there. Now, Brantley states that he believes that the children were attacked first, based on Darlie's statement that she had given. But he also can't say either way who was attacked first. And even when it comes to the boys, when it comes to the screen, he also can't determine if the window was open or closed because there isn't any information about where these bread knife particles were found on the knife. Because only one knife was found at the scene, and the one that was covered in blood, and this is the only murder weapon Brantley believes, was used in the commission of the crime, that it was just the one knife and this is the knife. We find out, though, in one police report that there was a neighbor who had woken up around 2:30 in the morning, according to Mulder, because she had heard screaming. And when she looked outside, she saw a black car with tinted windows. She had assumed where the screaming had come from was a slumber party that was happening next door and went back to bed. But then she was again woken up by the police and the ambulance sirens. Now, Brantley didn't remember reading this information, but when Mulder asked him, hey, would this even change your mind? He said no, and so the information wasn't located for him to review. When it comes to the vacuum being where it was and this cord being underneath it and the bloody footprints underneath all of that, Brantley is asked if he talked to the first officer on the scene to find out if the vacuum was there when he arrived. Now, Darlie hadn't mentioned it in her statements, this vacuum, which Brantley found strange. But then again, he didn't talk with Waddell either, and one of the first officers on the scene, and just relied on what he had been told by other officers. It's Brantley's opinion that it was one person who killed both of the boys, who harmed Darlie and also planted the sock. But he can't give any kind of chronological timeline of events as to how this would have happened. So the idea comes up when they're discussing this mud in the garage when there wasn't any, about the lighting outside and how the light would have triggered if someone was out there. So a perpetrator may have known to stay close to the house to avoid setting this light off, and in doing so may have brought mud inside. So let's just talk about this for a second. Because the whole reason that Brantley brings this up is like, well, if somebody stepped in, the grassy area and there was dew on the grass and so forth and so on, that this would mix with the dust or what have you. So let's talk about this dew. The dew would, like I said, according to him, have mixed with this dust and this dirt and formed a kind of mud. However, based on historical weather records, it was unlikely that dew would have been on the ground at all. Now, that being said, it's been mentioned a couple of times that there was a thunderstorm the following day. So remember, this crime happened on the 6th of June. So to me, the following day means the 7th, right? Historical weather data does not show a thunderstorm on the 7th of June in 1996. So this was a little bit curious. But, and this could just be a matter of semantics or just not being accurate when they were talking about it, on the 6th, there was moderate rainfall in the area. And I think this gets a little confusing because, like I said, to me, the next day means the following day or the 7th of June. To the people talking about it, it could mean the same day, but later in the day. Because obviously, the crime happened in the early morning hours of the 6th of June. It was this day that the moderate rain occurred, and it was like 0.55 inches, which, according to what I learned, could be from a brief and intense storm or rainfall over several hours. But since they talked about a thunderstorm, we're going to assume it was this brief and intense thunderstorm. It also means that the ground would be very wet, and it's likely that there would have been puddles and surface runoff. Now, the next day, the 7th, there was a little bit. There was like 0.04 amounts of rain or whatever. It's actually considered a light rain or drizzle. So let's move on to when Mulder starts talking about the lighting in the backyard. And from what I've gathered so far, this lighting is on the outside of the jacuzzi. I could be wrong. There might be other locations of this lighting that just kind of get triggered. I don't know if there's one outside the back patio doors. But anyhow, Mulder talks about how the state had an officer, and we find out later it's Sergeant Neighbors who did this, perform tests to see if this light would go on if someone were to walk on the sidewalk in the Routier backyard. And then Mulder mentions that, quote, the state hasn't seen fit to bring him in as a witness yet, implying that the officer couldn't get this light to go off if someone was walking on the sidewalk. And this, of course, causes an objection. And this is where it was left in this episode. They move into the garage area in the next episode. And I'm really looking forward to that. And that'll do it for today. Thank you all for listening. You are all so, so appreciated. If you liked today's episode, please give it a thumbs up and leave a comment on our YouTube podcast page. I love reading your insights and your feedback and your thoughts about all of this. Don't forget to subscribe as well so you don't miss out on future episodes. You can find the link to the YouTube page for this podcast in the show notes below. So thank you again. We will talk very soon. Bye for now.